The Second Judicial District Court of the State of Nevada is now in session. The Honorable Connie Steinheimer presiding.
Thank you. Please be seated. We will begin with case number CB 21-01595. If counsel for the plaintiff will identify themselves.
Your Honor, good morning. Ben Field for the plaintiff. I'm appearing from Arlington, Virginia. I received notice of this hearing and have no objection to it being held remotely.
Thank you.
Good morning, Your Honor. Jordan Smith for the plaintiff. I am in Clark County, Nevada. I received notice and I have no objection.
Thank you.
Good morning, Brian Morris for the plaintiff. I'm in Fairfax County, Virginia, and I received notice and have no objection.
Okay, thank you. Also appearing on behalf of the defendants, please identify yourself at this time.
Good morning, Your Honor. Adam Honey, bar number 9588, appearing on behalf of the defendants. I received notification of these proceedings and I have no objection. I'm located in Clark County, Nevada.
Thank you. And Mr. Honey, you are representing the individuals as well as the State of Nevada Department of Public Safety?
That is correct, Your Honor.
All right, thank you.
You're welcome.
This is the time set for a hearing on a motion for summary judgment and a counter motion for partial summary judgment. And so what I'm going to do today is allow the plaintiffs to argue in the defense, and each of you may argue your positions, and then we'll allow for a rebuttal opposite the other person's position. Really, these are cross motions in a way, in that one is the counter motion for partial summary judgment is contained in the opposition for the original motion for partial summary judgment. So that said, if everyone's agreeable to that format, we can proceed with the arguments now. Anyone have any objection?
No, Your Honor.
No objection, Your Honor.
Okay. Then now, Mr. Field, are you the going to argue today?
Yes.
All right. Then you may proceed.
Thank you, Your Honor, and good morning. May it please the court, Stephen Lara was driving to visit his daughters when he was pulled over outside Reno by the Nevada Highway Patrol. The officer seized his life savings, which he was carrying in cash. But the Highway Patrol didn't follow Nevada law and give Mr. Lara the protections that the Nevada legislature has set out for property owners in civil forfeiture. Instead, NHP handed Mr. Lara's money to the federal DEA as a so-called adoption to forfeit under federal law, which is much less protective of property owners' rights. The Highway Patrol stood to get to 80% of the proceeds back through what are styled equitable sharing payments. As a result, Mr. Lara was stuck in limbo for nearly 8 months as the federal government blew through its own deadline, forcing Mr. Lara to bring an independent lawsuit to get his savings back. Neither NHP nor the DEA ever charged Mr. Lara with a crime or presented any evidence that he committed a crime. Both sides agree that the undisputed facts tee up a purely legal question that the court should decide now. Did NHP have authority to give Mr. Lara's money to the federal government to adopt, or was NHP required to go through the Nevada law forfeiture process? The court has already answered this question in Mr. Lara's favor in ruling on the motion to dismiss. The government's cross motion is making the exact same arguments this court already rejected. The government's motion is essentially a motion for reconsideration, but it hasn't presented anything new to change the court's mind. The court should enter judgment for Mr. Lara as to liability on the first claim. Rather than repeat the briefs, I'd just like to focus on what I think are the few most important points that supported the court's ruling at the motion to dismiss stage. First, the provisions of Nevada forfeiture law that make it most obvious that Chapter 179 is the exclusive forfeiture system for state officials. Second, the conflicts between Nevada and federal forfeiture. And finally, I'll briefly address the government's counter-argument and why the court was correct to reject them before. The first and most important thing to emphasize is the statutory text. On pages 11 to 16 of our motion, we lay out the many provisions of NRS Chapter 179 that make clear that it is the exclusive way for Nevada officials to pursue forfeiture. It's rife with mandatory language like shall and must. As this court put it in its motion to dismiss order at page 15, Nevada law invokes statutory requirements on how NHP is to deal with seized property. And federal adoption allows agencies to, quote, circumvent the procedural requirements. The court's ruling was correct, and today I'd just like to highlight the two provisions that I think are most decisive in supporting the court's conclusion at the motion to dismiss stage. First is NRS 179.1171. Subsection 3 of that provision says, quote, if a law enforcement agency seizes property, the property must not be forfeited unless, end quote, one of only two things happens. Either the parties come to an agreement or, quote, the agency files a complaint for forfeiture in the district court for the county in which the property is located, end quote. Those are the only two options. Without an agreement, property must not be forfeited unless the government files a forfeiture complaint in the county district court, which for Mr. Lara would have been in this court. That is the central provision the court looked to in its motion to dismiss order at pages 13 and 14, and it could not be clearer. But the government wants a third option. They want the court to amend the statute to add something like the agency may instead give the property to another government to forfeit under whatever procedures that government prescribes. But the statute doesn't say that, and the court shouldn't read in language that doesn't exist. The other most important statutory provision is NRS 179.1156, which lays out the scope of the general forfeiture provisions in Chapter 179. It says that with a couple specific exceptions that aren't at issue here, that Chapter 179's general forfeiture provisions, quote, govern the seizure, forfeiture, and disposition of all property and proceeds subject to forfeiture, end quote. The government is again asking this court to rewrite the statute to create an exception for federal adoptions. So Chapter 179's plain language governs all forfeitures, not just those that the government chooses. I think that those are sufficient to report judgment for the plaintiff, and those were the key provisions that the court relied on before. But the second major point to emphasize is just how incompatible federal forfeiture is with the system that the Nevada legislature has laid out, right down to the burden of proof. By having the DEA, quote unquote, adopt this forfeiture, the government eviscerated Nevada's safeguards. The table in our motion at pages 17 to 19 details all the ways that federal law undermines Chapter 179's guarantees. Today I'll highlight two distinctions I think are especially salient because they directly caused Mr. Lara's injuries and gave rise to his other constitutional claims. Specifically, the lack of prompt judicial hearing in the federal system and the financial incentives it gives for overzealous seizures. Starting with the lack of a prompt hearing, Mr. Lara had to wait nearly 8 months to get his life savings back. That wouldn't have happened had the government followed Nevada law, which would have guaranteed Mr. Lara access to a neutral judge in this court and the ability to file for return of his property no later than 60 days after the seizure. Instead, Mr. Lara was thrown into a federal administrative forfeiture scheme where the DEA got the first crack at evaluating its own forfeiture without a court supervision. Federal law allowed the DEA to avoid filing in any court for at least 180 days and potentially indefinitely. As it happened, the DEA didn't even honor its own statutory deadline, which forced Mr. Lara to file his own lawsuit. And once faced with the prospect of a neutral judge, the government announced it was returning his money the very next day. If Mr. Lara had instead had access to Nevada's procedural system and been able to file within 60 days, as Nevada would have provided, he would have gotten his property back at least 5 months sooner. The second problem with the federal system that highlights its distinctions from Nevada is the profit motivation. One of Mr. Lara's other claims in this case is that federal forfeiture creates due process problems by giving law enforcement financial incentive to seize property that agency then gets to keep. And Nevada law is attuned to this danger. That's why Chapter 179 caps the amount of money that a seizing agency can keep, and it requires that forfeiture, quote, must not be used to pay the ordinary operating expenses of the agency, end quote. It also promotes transparency through detailed reporting requirements. But on these fronts, federal law does the exact opposite. It requires that all equitable sharing payments go to the seizing agency and be used to supplement its regular budget, creating a direct profit incentive for the seizing officers to fund their own activities. And federal forfeiture reports are bare bones compared to the requirements of Nevada law, undermining the transparency the Nevada legislature wanted to promote. And those are two examples, but the logic of the government's position would allow Nevada law enforcement to opt out of every protection in Nevada law. If the federal government or another state government allowed forfeiture, say, without any notice to property owners or without any judicial supervision at all, the government's logic in its cross motion would say that there wouldn't be any problem with the Nevada official farming a forfeiture out to those other governments. And that just cannot be what the Nevada legislature intended when it passed a highly reticulated system with expansive protections for property owners. And the third and final major point I want to cover is briefly the government's counter-arguments. The most important thing to say about these is just that they are the exact same arguments that the government made at the motion to dismiss stage, in which this court already properly rejected. In its motion to dismiss order, the court effectively invited the government at page 15 to find some other source of authority to engage in the federal adoption scheme. But the government's cross motion has nothing new, and there simply isn't an escape hatch in Nevada law to the mandatory language of Chapter 179. The statutory provisions that the government invokes for the second time all have the same central shared flaw that this court already identified. Those provisions allow government agencies to cooperate and to share forfeiture proceeds, but none of them gives any government agency any forfeiture power outside the bounds of Chapter 179. The Interlocal Cooperation Act is the government's primary authority, and it's especially an opposite. As this court already said at page 15 of its MTV order, the Interlocal Cooperation Act is, quote, clear. Quote, the law enforcement agency must have an underlying state statute to authorize their actions. The Interlocal Cooperation Act is a law about letting local governments pool resources to provide public services. It does nothing to give government agencies new powers they don't already have, especially not forfeiture powers that would override the other provisions of Nevada law. Unless the court has any questions at this time, I'm happy to address anything further on rebuttal.
Okay, I have no questions, thank you. So we'll move on, Mr. Honey.
Thank you, Your Honor. As you know, I'm new to this case that's been active for just at the end of August for over 3 years. As somebody coming in as the third person in, I would first just say that I think that the parties to this have briefed the substantive law of this to a great extent and very well done. There's important legal questions for this court to decide at this time. I'm going to mostly focus here on a substantive issue, which I think has been ignored, is simply the fact that Mr. Lara, through his counsel, have in fact turned this judgment in the pleadings into essentially a motion for summary judgment. They make numerous assertions that have nothing to do with the purely legal question here, and it goes far beyond what they say in their reply that it's being done just for context. There is so much of it that it goes far beyond context, and it's really done for its prejudicial nature, and it has no probative value to this. And once that bell's rung, it really can't be unrung. And quite frankly, Lara knew better than to do it. He could have concisely summarized what this case was about in very generic terms and stuck to the purely legal question that the parties agree to what is at hand here. When he makes arguments about the billions of dollars that the equitable sharing program has raised throughout the United States over 20 years, what is the defense left to do? Am I supposed to argue that since the year 2000, the number of overdose deaths in this country have grown fivefold? Or am I supposed to start arguing the purpose of the DEA and equitable sharing program? Am I supposed to argue that deaths decreased for the first time for overdose deaths in 2022, 2023? I think the answer is no, because this is a judgment on the pleadings, and those statements go beyond the pleadings. And again, that bell simply cannot be unrung. The second point I want to make is it appears that plaintiff is trying to invoke the law of the case doctrine in trying to shoehorn Your Honor into relying on its order and decision to the motion to dismiss. That's not how the law of the case doctrine works. The law of the case doctrine works generally when a higher court, such as an appellate court or the Nevada Supreme Court, rules on a legal issue, and then that must be followed throughout the remainder of the case, whether it be in the lower court or a second subsequent appeal. This court is not bound by its decision at the motion to dismiss stage. One other thing I'd like to point out is in agreeing that the federal forfeiture system exists and that it's legitimate, and I mean the plaintiff agreeing to this, the fact that there's a difference between the two systems makes perfect sense. In this system, the Drug Enforcement Agency gives its administrative support and prosecution support for forfeitures. The DEA presumably is focused on reducing the amount of illegal drugs and drug trafficking and enforcing the drug laws of this country. It makes sense then, if they're going to use their resources, that what they're going to do the equitable sharing, that they then want that money to come back to law enforcement to further their agency objectives. As where, for example, there already is money that goes to the public schools from the federal government. There's already money for Medicare that comes. There's already money that goes for highway. So the DEA wouldn't want to use their resources to equitably share money to go back to a general fund. They want to share that money back to, again, reduce the amount of drugs that are on the street and stop this, the epidemic that we have here. There's never been any argument that the federal system is somehow either unlawful or unconstitutional, just that it was different. And it's okay, it's different. There's valid reasons for why their system works differently. Now, as to the substantive arguments, like I said at the beginning of this, I think it's been fully briefed by the parties. And in regards to the substantive issues, I'll submit it on the briefs.
Thank you. Mr. Field?
Thank you, Your Honor. So I'll start with the procedural objection that Mr. Connie raised. I think that all the court needs to look at is page 3 of the government's cross motion, where it agrees with plaintiff that the only relevant facts are, quote, that NHP did indeed seize large money to pursue a federal adoption and then actually did hand the money over to a federal agency for equitable sharing. The government goes on to say those relevant facts are undisputed, and the question about whether federal adoption and equitable sharing are ultra vires is purely legal. And elsewhere in the cross motion, the government says the court must decide the issue under 12C. Of course, the court can set aside all other background information. The court's aware of the complaint, it's on the docket. The court's aware of the briefing at the motion to dismiss stage. There's no procedural reason that reminding the court of what the general context of this case is would preclude the court from reaching judgment on the pleadings. So I'm happy for the court to have heard what Mr. Connie said about his policy arguments for why he thinks that the equitable sharing program is good. The court can set those aside and simply look at the statutes and decide the legal question: does Nevada law allow Nevada law enforcement to participate in equitable sharing? Both sides agree that's a purely legal question that's teed up for judgment on the pleading based on the undisputed facts. Second, Mr. Connie raised concerns about, plaintiff trying to invoke the law of the case doctrine. We're not doing so at all, Your Honor. Of course, Your Honor's decision at the motion to dismiss stage was interlocutory. The court has all the discretion in the world to reconsider it if it wants to. The point that we're making is just that the government is making the exact same arguments that it did at the motion to dismiss stage. The court rejected those arguments, we think correctly, and so we think that the burden, the court can obviously reconsider, but the government hasn't actually provided any new information that would lead the court to reconsider. And so I think that the court should stick by its well-reasoned decision at the motion motion to dismiss stage. And now that we're in a procedural posture where the plaintiff is able to cross-move, the court cannot just deny a motion to dismiss, it can also affirmatively grant judgment as to liability to the plaintiff. So we're not saying that the law of the case or anything like that governs. We're simply saying the court got it right the first time. The government hasn't presented anything new. The court should stick to its original decision. And we provided additional briefing and support that wasn't in the MTD briefing to further support the court's original decision. And finally, I heard Mr. Honey make a series of policy arguments about why the DEA might run a system the way it does. And that's really neither here nor there. What I didn't hear Mr. Honey make is a response to any of these statutory arguments based on Nevada law saying that there's any authority for Nevada to go outside the mandatory terms of Chapter 179. As this court said at the motion to dismiss stage in ruling against the government's preemption argument, all the federal system sets up is an offer to the states that they can accept or decline as they wish. But instead, as the court recognized, the legislature has instead set out, quote, strict requirements on law enforcement agencies. That was at page 14 of the court's order. That Nevada law invokes statutory requirements on how NHP is to deal with the seized property. That's at page 15. And so it's true that there's a federal system out there. Whether it's good or bad, obviously, we disagree with the government on that, is beside the point. The question for the court is simply whether the statutes in Chapter 179 allow the Highway Patrol and other state agencies to take property that they have seized and rather than follow the mandatory statutory requirements, instead give it to the federal government. And I think that the plain statutory text makes that clear that they cannot. And it just wouldn't make any sense for the legislature to have written this highly reticulated scheme with the expectation that law enforcement would instead give the property to a system that doesn't respect any of the property rights protections that Nevada enacted. And so I think this is a very clear-cut case of statutory interpretation that the law just says, if you want to forfeit property, you have to do it this one specific way. And you cannot give it to the federal government. I just end by saying, making a sort of colloquial analogy. If you tell a child, after dinner, if you want to have dessert, the only way you're going to get it is if you either clear the dishes or clean your room. If the child instead plays video games, it is clear to the child that he's not going to get dessert. And the legislature was just as clear to state agencies here, especially in the two statutory provisions that I covered with the court today.
Okay, thank you. Mr. Honey, do you want to be heard in rebuttal with regard to your arguments?
No, Your Honor, I will submit it on the briefs.
All right. Counsel, this is an issue of first impression, and the court wanted to hear your arguments today before I ruled on this important issue. So we are going to take this under submission. I do not believe I need a transcript prior to being able to rule on this. I don't think your arguments were so complex that we can't move on without the transcript. But does either party wish a transcript prepared?
Plaintiff would like a transcript.
Okay. So the court reporter will prepare a transcript. Once the transcript is prepared, we will submit the motion to the court. Since we're going to have a transcript, I want to have that before I enter my order. So we will review that before we enter our decision. We'll take it under submission as soon as the transcript is prepared. Normally it'll take 30 days. This court reporter is at about what you think?
For this, it should be like 10 days. I can get it to you guys.
Okay. So after it's filed into the record, the court will take this matter under submission. Does anyone have anything else for the court today?
Not very wrong.
Okay, so barring, depending on what the ruling is, we still have a trial set for next summer, as well as hearings set. We may, of course, depending on the court's ruling, change some of those dates and make decisions, change some of those appearances. But we will do that by letter and let you know. Thank you very much for your appearance today. We will be in recess.
All rise.